Thanks, Mr. Chairman. The way AI interacts with intellectual property rights, particularly copyrights, is a critical topic we can't overlook. America's creative industries, including software, music, movies, literature, collectively contribute over $1 trillion to our economy each year, employing millions of people. While AI can be an incredible tool that unlocks further creativity, writers, artists, musicians, and others are rightfully concerned about what technology means to them personally. Should AI companies be able to use their materials freely as, quote, fair use, unquote, or should they receive compensation when their works are used to train AI models? I want to tell you, Chapter 1, how I discovered intellectual property. I was an attorney in Springfield, Illinois, and in a rash moment decided to buy a restaurant. So I joined a few friends and bought a restaurant, and we had live music. And I got a phone call one day from a fellow who said, I just was out at your restaurant. I said, great, did you have a good time? Couldn't have been better. Saturday night, the music was terrific. And I said, well, I'm glad you had a good time. And he said, you played 10 BMI tunes and 6 ASCAP tunes. I said, no, I didn't. I didn't play any tunes. He said, well, the way the law is written, you're responsible for the fact that copyright material was used by you to make a profit at your restaurant. I said, tell it to the judge. He said, no, wait, before you say that, call your friend over in Jacksonville, Illinois, a few miles away, and ask him about a similar experience, and his reaction was the same as yours. I called my friend who said, ask him how much money he needs each month for ASCAP and BMI, and we started paying it. That was my first course in intellectual property. I hold on to it to this day. So how can creators compete with AI products that generate content at the push of the button, especially when the content might mimic or even produce their own work? These are just a few of the questions that we're going to consider in this hearing as we try to find the right balance between promoting technological innovation, protecting the work of our nation's creators, and continuing to incentivize creativity in years to come. We must recognize that AI innovation and protection of intellectual property rights are not mutually exclusive. That's why it's troubling, as I listen carefully to the chairman, to hear stories about steps big tech companies are taking to train their AI models on copyright materials without compensation to the creators of these works. For example, rather than license authors' works, companies like Meta and Anthropic have obtained copyright materials from sites that host pirated copies of the author's books and writings. Anthropic pirated over 7 million books from shadow libraries. As Anthropic's CEO put it, Anthropic had many places from which it could have purchased, but it preferred to steal them to avoid, quote, legal practice business slog, whatever that means. While Anthropic later became not so gung-ho about training their LLM on pirated books for legal reasons, it kept the pirated copies that it had already downloaded anyway. I don't get that. As a judge in the Meta case recently put it, quote, companies have been unable to resist the temptation to feed copyright-protected materials into their models without getting permission from the copyright holders or paying them for the right to use their works for this purpose. This hearing is going to be interesting. Thanks, Mr. Chairman.